Hello and welcome to another episode of Cut to the Chase, where we chat up on laws beyond citations. I'm Sanya, and today I'm going to be in conversation with a lawyer named Shubhendu Anand, who's been kind enough to join us on an issue which has plagued the country for a very long time, that is the pendency of court cases across India. Now, Shubhendu is a lawyer who's primarily practicing in the Supreme Court of India and tribunals in Delhi. He is also the partner at Atharva Legal LLP, which is a full-service law firm. He did his postgraduate in intellectual property law in Queen Mary, University of London, where he was a British Chevening Scholar in 2016 to 17. He graduated from the Tata Institute of Social Sciences, Mumbai, and holds a law degree from the Campus Law Center, University of Delhi. Hi, Shubhendu. Thank you so much for joining us today. I'll just cut straight to the chase. What do you think is the issue in the country so far as pendency is concerned? Now, I'm going to keep this restricted to the Supreme Court because, I feel like it's a huge ambit if you're talking about all courts. So far as the Supreme Court is concerned, we know that there has been a 27.35% rise in the last 5 years so far as pendency is concerned. Now, these are official statistics. So what is it that is causing this issue?
See, the problem with pendency in the Supreme Court is a very complex problem. And if you look at it in the last 5 years, as you said, that the rate of pendency increase in the number of cases has gone to around 28%. It is not a result of just one problem. In the last 2 years, if you see because of the COVID, the rate of disposal of cases was quite low because the court was not functioning at its full strength. So that is one problem due to which the rate of disposal has gone down. But more importantly, what is the problem here is a very complex issue of both adjournments and what our Chief Justice of India said in one of the events, that it is luxury litigation. Now, luxury litigation is a form of litigation, according to him, where a petitioner who files a petition in the court and then tries to frustrate the whole process by filing multiple applications on that petition. Now, what happens in that if you file a petition straight away and try to get the case disposed of quickly, if I'm the other party, I would try to get the case disposed of quickly. But the person who has filed this litigation, and if he wants to linger on to that, what he will do is that he or she will start filing multiple applications to that petition, and then it would start getting delayed. So that is why in a number of cases that you see today in Supreme Court, whether it be of corporates or of highly influential clients, highly influential individuals, what you would see is that they try to engage into what is called by our Chief Justice luxury litigation, wherein they would file multiple applications. And that frustrates the whole process of speedy disposal of cases. So that is one big problem that I see here. Currently, I don't think there is a problem of the scarcity of judges in the Supreme Court. The Supreme Court already has 32 judges who are working. So that is not a problem. Last 5 years, data has shot up largely because of the COVID situation in the last 2.5 years. Otherwise, one constant problem, as I just discussed, is luxury litigation.
But so, of course, you're talking about luxury litigation and you're talking about the fact that a number of applications are filed often in this similar matter. So these are two things that we're looking at. But when we're looking at data from the past, so far as pendency is concerned, even before COVID had begun, so COVID only started 2 years ago. From the way I see it, I'm seeing numbers which show a huge abysmal rise even since 2014, 2015. And it's only been going up. And it's not been flatlined or it's not been going down. It's only been going up. The whole idea is, of course, there is a problem, number one. And secondly, when we're talking about adjournments, and we are saying that that's not the only problem. We saw Justice Ravindra Bhatt the other day saying that, to a senior counsel that, you want us to be a laughing stock of the country. Have you seen the pendency rate? We are not going to give you adjournment. So he obviously meant that pendency rate is going up because you're seeking too many adjournments. So is it really that simple? I mean, of course, apart from the fact that you highlighted there are luxury litigations involved and, the COVID situation happened.
So, as a member of the bar, I don't know how appropriate it would be for me to say this, but to a large extent, the delay can also be attributed to the lawyer's tendency to seek adjournments. Now, a lawyer does not seek adjournments merely because he wants to seek adjournment or he is not fully prepared or whatever reason. It is more often than not, it is because of the client's pressure. The client would not supply documents. The client would not brief the advocate appropriately or thoroughly, and that can be a reason for the lawyers seeking adjournments. And there can be other reasons. I mean, lawyers can take the luxury of taking adjournments themselves, but there are a number of factors that play into when lawyers seek adjournment. So adjournment obviously is a problem. Justice Ravindra Bhatt was absolutely correct when he said that a number of cases are pending in the court also because lawyers seek very frequent adjournments. So that is definitely a problem. And the problem is not as simple as one may think, that a lawyer simply goes and seeks adjournment because he does not want to argue the matter. There are a number of factors that play into it. And one of the major factors is the client's non-responsiveness or the client's failure to brief or supplement the documents to the advocates. So that is another problem.
The way I see it now, I feel like there is being a shift of responsibility here. So here we are seeing that we are seeing judges who are saying that, okay, lawyers are taking adjournments. We are working hard, but the lawyers are taking adjournments. Of course, lawyers, they have multiple reasons when they are taking an adjournment. It can be anything, right? It can be the client, it can be a situation where they have a personal issue, or they have other matters to attend to, which may be more pressing at that point in time. When you go to the government, they say that, okay, we are ready to give you full support. We can give you infrastructure. We want to get rid of pendency. But then, the conversation suddenly drops. It picks up and then it drops. We talk about it, that there is pendency. We have statistics. We have conversations, debates, panel discussions about it. But I don't think anything really comes out of it. It's been 30 years and we have been talking about the same issue since a very long time. Do you think there is a reform that can be really put in place, that one reform that probably can change things around?
See, debates cannot solve this problem. To be very honest, debates are not going to solve this problem. What is going to solve this problem is a concrete step taken by the government and by the judiciary as well to address this problem. And what is that? Is increasing the number of judges in subordinate and high courts. I mean, for a moment, I'm going to digress from the fact that we were discussing Supreme Court. Now, let us for a moment shift to High Court and subordinate courts. So, around 4.5 crore cases are pending in the subordinate courts alone. 4.5 crores, that is like 45 million cases. And around 1.5 crore, around 1 crore cases are pending in high courts, if my data is correct. Not really, but around 1.5 lakhs cases are pending in the high courts, and 4.5 crore cases are pending in the subordinate district level courts. So why is this problem?
Let me add to that. There was a total pendency of 3 crores across courts as of April 2018, and from April 2018 to now across courts. So this also probably includes Supreme Court, according to what I have with me. It's been 50% rise in pendency across courts. So yeah,
that is why we have a figure of 4.5 crores cases pending across the courts. Now the problem is, one of the largest issues here is the lack of judges and lack of infrastructure in the courts. So we don't have enough judges to address the issue of pendency. a number of district courts are working with 50% of the required number of judges. So the vacancy rate across India in the subordinate judiciary is around 30 to 40%. In the high courts, it's more, it is like 40% to 50%. I mean, a number of courts are there in India where the high courts are functioning with just 50% or 60% of the required number of judges. So that is a problem, which is the biggest issue that the government has to address. So recruitment of judges is first and foremost task which the government should focus on. Apart from that, what the courts can do is that they should issue an advisory, or they should issue a writ to the lower courts, stating the timeline in which the court has to dispose of a matter. Now, if you don't issue that, there will be several factors. Somebody would come and seek adjournment. Somebody would say that the registry is not responsive enough. Somebody would come. So you have to fix responsibility at every step. You have to fix responsibility at the judges, with the registry, with the advocates who are officers of the court, who don't just have to address the issues of their clients, but also have to act as responsible officers of the courts. So they too have a duty towards this. So the courts, the High Court or the Supreme Court, must fix responsibility at every step to ensure that the cases are disposed of speedily. And having said that, it is the most important factor in this is the number of judges that we have in the courts, and that has to increase significantly. And only government can do it. I mean, subordinate judiciary postings have to be done by the government. So that is where the government's role comes into play, and it's a very important role to be played. So these are the two things I believe would be able to address the issue to some extent. One is the court fixing responsibility and fixing a timeline to adjudicate the cases, and the second is the government filling up the vacancies in high courts and subordinate courts. In fact, I was looking at the statistics and I realized that even in the fast track courts, I mean, the government has the provision for fast track courts, and even in the fast track courts, till last year, around India had 956 fast track courts, and in those 956 fast track courts, around 10 lakhs cases were pending. 9.5 lakhs cases were pending. So I really don't know how to address this issue, because the government can come up with a solution, like you can have a fast track court, which is a solution to for speedy disposal of cases. But even there, the pendency is like 9.5 lakhs, which is really worrisome.
Absolutely. So, I mean, when we look at it from that perspective, and we see that there needs to be a holistic overhaul of certain systems, we may have to put in reforms in place. But when you're talking about fixing timelines for courts such as the High Court or the lower courts, we also have to look at the timelines that the Supreme Court may have to take or may have to adhere to when they are, hearing a matter, or when they are listing matters for that matter. How do we get accountability from the top court in this regard?
See, no one can fix responsibility on the Supreme Court, but the Supreme Court itself. I think one of the problems within the judiciary, within the Supreme Court, is also the problem with the registry. The listing of the cases is very problematic, in the sense that a case gets listed today, and then the next date for listing, I must say that the advocate on record and the clients fulfill all the demands of the registry within, like in terms of filing and in terms of supplying the documents and everything, curing the defects, everything. So even then, I have seen cases getting listed 1 year after the first hearing. So a case gets admitted on the first date, and then the next date for the same case comes up after 1 year, comes up after 6 months, comes up after 8 months. So there obviously is a problem, and the problem is that even in important cases, the Supreme Court is not ready to hear the cases within the time frame. I think if the cases get listed, and it is a problem that is continuing for the last 20 years, 30 years, and that is why this delay happens, because the court is also of the opinion that I have to finish off the previous cases which are pending for quite some time. And in this process, when they are trying to address the issue which is of previous years, they are in the process, they are delaying the cases that are filed at that point in time. So while they are disposing of the cases of previous years, here is a situation where the cases of the current year are getting clogged, and then they would become a case for pendency in the next coming years. So that is an endemic problem. I mean, I don't see a solution to it unless the court fixes a timeline for itself too. I mean, the Supreme Court fixes a timeline for itself too. To dispose of the cases, and should issue a advisory to the advocates as well, that look, unless there is a very, very serious circumstance, no adjournment can be given, one, and two, the pleadings have to be completed in time, all the documents have to be supplied and exchanged within time, and the hearing should take place within the time frame. I think that would solve the problem to an extent in the apex court.
Well, I also think that I disagree with what you said in the beginning of the conversation, that debates will probably never solve the issue. But I think discourse is something that will eventually lead to some action being taken. So I think that we need to continue to do this and talk about this and figure out solutions, talk to people who are in the system, who are working in the Supreme Court or working across courts, who are judges, and actually figure out a long-term solution to this endemic problem, as you said.
I mean, we have seen chief justices after chief justices giving speeches about how the court is burdened with a number of cases and the pendency is huge and everything. But who has actually come out and suggested a way to solve that problem? I have seen none of them. I mean, every single chief in the last 10 years of my presence in the court, both as an intern and then as an advocate, I have never seen a single Chief Justice of India not talking about the problem of pendency in the court. And I have also not seen any of these judges who have done anything substantial to address this issue, because the pendency continues to grow. I mean, it is not something that, I mean, if any judge would have done anything for to address this issue, the pendency should have come down. The pendency, as you just quoted the numbers, pendency has gone up.
Correct.
So, I mean, everyone has talked about it. No one has done anything about it. So that is why I'm skeptical of the debates, and I'm skeptical of the speeches wherein the politicians and the judges come and say that the problem is there and there is pendency, but what is being done?
But there is no solution-oriented approach being adopted to this, and there's only conversation. And I agree with you there.
So I think this issue at the Supreme Court level can be addressed by Supreme Court itself. The government cannot do anything about it. The government has plans to digitize the whole thing, and a number of steps are being taken for digital filing and digital, but it's still in a very nascent stage. We are not fully prepared. I mean, both lawyers, all at every step, lawyers and clients and everyone, litigants, they are not fully prepared to adopt the digital technology in courts, because courts are mostly very traditional places. So there will be, I mean, it will take a lot of time for the entire fraternity, both litigants and the advocates and the judges, to adopt to technology, which is taking place, but it is taking time. And technology alone is not a solution, to be very honest. Technology alone cannot be a solution. The solution is fixing responsibility. The solution is fixing a timeline and adhering to the timeline. So that is where the solution lies, according to me.
So I guess there's some food for thought that we have with us today, and let's just ponder on it and work further on this issue, which is plaguing our system since times immemorial and since eons. So let's hope for the best. We'll we're really glad to have you today. Thank you for joining us, Shubhendu. It was wonderful, and hope to have you back soon again sometime. Bye-bye.